Welcome to Your Money Guides, brought to you by Interface Financial Planning. Hello. In today's guide, I'm going to be talking about pensions and divorce. Couples going through a divorce may be faced with a situation where their pensions or the pensions of a spouse or partner is a major consideration, as pension rights form part of the assets when it comes to divorce settlements. The factors relating to pensions are often complex, and there is a threat that settlements are reached where the full range of options have not been properly investigated or analysed. The start point is always the same. Couples should ensure they have the full range of options with the advantages and disadvantages of each properly mapped out and explained to them. This is not just the case prior to any settlement being reached, but probably in most cases before any negotiations towards a settlement takes place. Pension rights form part of assets when it comes to divorce settlements. The court has to take them into account when the couple's affairs are assessed and a settlement agreed. The rules are the same when it comes to a formal dissolution of a civil partnership. Where I discuss divorce throughout this guide, the same points and factors will apply to civil partners. A pension or pension rights can often represent one of the biggest assets. Indeed, in a reasonable number of cases, it may be the biggest asset. The issues around pensions for people going through a divorce can often appear perplexing. I aim to provide some simple guidance throughout this guide, which will help translate these complexities into easy to understand terms. This guide is not meant to act as a technical document. Anyone in the process of a divorce, whatever the current stage, who has a pension or their spouse has a pension, should seek out professional advice from a pension specialist. This is a guide which outlines the top-level aspects to this subject. Armed with this information and understanding, I hope any individual listener will be better set to deal with all the various aspects they need to consider when they discuss matters with their advisors. It's worth noting at this point, the laws applying in Scotland vary from those in England, Wales and Northern Ireland. Most of the basics are the same, but there are some important variations in how the different payments may be treated. I will cover these and all the differences a little later on in this guide. There are three ways that a pension can be treated in a divorce. Firstly, pension offsetting, balancing the pension right against other assets. Secondly, pension earmarking, arranging when one person's pension comes into payment, part of it will be paid to the other person. And thirdly, pension sharing, splitting the pension at the time of the divorce so that both parties get their own pension pot for the future. Which method will be best in any particular situation will be decided by a range of different factors and could be subject to negotiation as part of the wider divorce settlement. It's worth stressing that the different options could produce very different outcomes. It's very important for any individual going through a divorce that they are properly advised which method is likely to work best for them, as the decision which to use could have far-reaching consequences. To understand how the options compare and the different aspects, I firstly need to examine each option separately. So firstly, there's pension offsetting. This is where the pension benefits are offset against other assets. As an example, a husband has a pension valued at £300,000 and the couple jointly own a house valued at £600,000. Offsetting would allow the pension to be traded against the house, and the husband may keep the pension and the wife will be able to keep the house, or some other trade-off based on respective values. However, the pension would remain with the husband. The wife would have no future claim on it or share in it. Next is pension earmarking. Earmarking is an agreement that when a pension comes into payment, a part of it, a set percentage, is paid to the ex-spouse or ex-partner. The relevant pension scheme provider receives written instruction from the court to make this payment. In England, Wales and Northern Ireland, the payment can be taken from a pension and/or a lump sum. In Scotland, it can only come from the cash lump sum. If there is a lump sum benefit on death in service, this can be earmarked. The court can order all or part of it to be paid to the ex-spouse or ex-partner and can order the pension member to nominate them. If an individual has retired and chose to have a guarantee on their pension, this could also be earmarked. The percentage to be paid is set at the time of the divorce, but either party can apply to the court to vary the amount. The percentage is paid when the ex-spouse or partner opens their pension pot. And finally, there's pension sharing. Pension sharing means that the pension is split as a percentage at the time of the divorce. The court issues a pension sharing order which states the percentage of the pension which is to be given to the ex-spouse or ex-partner. This is worked out as a percentage of the pension's transfer value. The transfer value is worked out at the day before the pension sharing order takes effect. This means that the value can be higher or lower than the value of the pension stated at the time the divorce proceedings started. The pension awarded to the ex-spouse or ex-partner is called a pension credit. This can be transferred to a pension scheme chosen by the ex-spouse or partner as long as that scheme is able to accept the transfer. If the ex-spouse or ex-partner does not make a choice, the scheme or provider may allow them to become a member of an existing scheme. Alternatively, they may transfer the pension credit to a buyout policy, sometimes called a Section 32 policy. If the pension credit remains in the existing scheme, the ex-spouse or ex-partner will receive the increases that the scheme gives to deferred pensions. Schemes can charge a fee for dealing with the administration of pension sharing. Pension sharing can also take place when the pension is already in payment, although the fees may be higher and the process is more complicated. So now let's weigh up these options against each other. There are advantages and disadvantages applying to each method, which may vary in importance purely dependent on the divorcing couple's circumstances. There is also another factor not often commented upon. The advantages to one party of one method may be a disadvantage to the other party. There can be conflicts in the interest of each party, which need to be dealt with, negotiated and balanced. This is such a specialist area that it's likely only a pension-qualified advisor will be able to provide the required individual assessment of which method is most suitable. In general terms, here are some examples of the advantages and disadvantages of the three methods. So firstly, the advantages of pension offsetting. Firstly, simplicity. This is often seen as the simplest method. The pension of one party is attributed a value, for example £100,000, and this is retained as an asset by that party, with the other party receiving £100,000 in value of some other asset. There's also the ease of administration. The offsetting is easy for both parties to administer. In addition, there is no need for a court order. And the disadvantages of pension offsetting include one party may end up with little or no ongoing pension benefit. A typical example would be where one party has a high pension value, an offset is agreed, leaving the other party with an asset, maybe the family home, but no pension entitlement, which could cause problems later down the line. Also, valuations may be difficult to agree or a fair offset to achieve. In theory, an offset is a simple arrangement. However, in practice, getting the value of the pension agreed and the appropriate split to work can be very difficult. For example, a pension may be valued at £200,000 and a property at £1 million. Offsetting one against the other without selling or sharing the assets in some way may not work in line with the percentage split that one or both parties seek. And the last disadvantage of pension offsetting is that death benefits from the pension may be lost, and this may be detrimental to the ex-spouse. Now the advantages of pension earmarking. These include both parties can benefit from a generous pension entitlement into the future. The nature of earmarking favours a situation where the future pensions will accrue with both parties able to benefit. Also, pension death in service benefits can be earmarked for the ex-spouse. And finally, where a pension is already in payment through an annuity, the ex-spouse can have a proportion of the ongoing annuity payment. And now the disadvantages of pension earmarking. These include loss of control for one party. The ex-spouse is dependent on receiving their pension entitlement whenever their former partner decides to retire. In addition, the scheme may change in future years. The member may choose to reduce benefits or even, in extreme circumstances, forego the future pension in favour of other means of saving. Another disadvantage is that income on a pension in payment will be taxed at the pension member's income tax rate. The income from the pension is payable first to the member and then only paid to the ex-spouse as part of the earmarked court order. This creates a tax charge which will be based on the member's rate, which could easily be a higher rate than the ex-spouse's, creating an unnecessary tax liability compared to other options. Also, earmarking ceases on remarriage. Should the ex-spouse wish to remarry, the earmarking will cease to apply. As well as that, earmarking ceases on death of the scheme member. The ex-spouse will lose all of his or her entitlement if he or she is predeceased by the ex-partner. And also, parties will need to remain in contact to manage the ongoing pension situation between them. Generally speaking, the disadvantages of earmarking can be so great and the risks for the ex-spouse so high, it's become a largely defunct option, only used when narrow circumstances apply. It's not a no-go, but it's likely in the great majority of cases to be the least attractive option of the three available. And finally, pension sharing, the advantages of which include both parties get a pension. This provides a completely clean arrangement where after the divorce both parties go their separate ways with their own pension entitlement. There is no ongoing attachment. Also, both parties get to make their own decisions after the divorce. As a consequence, each party can make their own independent decisions going forward about the investment approach, when to retire and adding further contributions. Also, the ex-spouse can remarry without affecting the pension rights, and the pension income will be payable at the tax rate of the receiving member. And the disadvantage of pension sharing is that for high-earning individuals who may be affected by the cap of the lifetime allowance, the amount that is transferred to their ex-spouse will count towards their lifetime limit. Let's now look at other factors and considerations. And firstly, the pension freedom legislation, which was introduced in 2015. This allows pension investors to freely access their pensions in a completely different way to before. These new rules have generally become known as pension freedom, as it expresses the nature of what an individual can do with their pension which they couldn't do before. In technical terms, these new rules have not altered the legislation in the context of pensions and divorces. However, there may be legal challenges to come down the line which could impact case law. That remains to be seen. Whilst the rules around divorces and the options available to divorcees with their pensions, by and large, are unaffected by pension freedoms, there are some practical implications which arise, which need to be noted. Firstly, let's look at offsetting. Offsetting is most likely to take place where individuals aim to achieve some form of parity between the value of the pension asset and the value of other assets. Pension freedoms can offer significant tax and potentially estate planning advantages for those who utilise the new rules. This could have an effect on perceived values when the offsetting negotiation is taking place. The greater flexibility arguably offers more value to a pension investor than before, as they have better ways available to them to organise how they access their pension. So how do the rules affect earmarking? Put bluntly, a pension investor could now bludgeon their pension, taking it all out on day one as a cash sum with tax deducted, which could have a significant impact on the application of earmarking orders. If the order is not highly specific, then this does open the door for a pension holder to avoid the terms of an order which is intended to earmark ongoing income, for example. This is complicated by the technical nature and to some extent by the terminology. Pension investors can opt to take all benefits as an uncrystallised funds pension lump sum, or UFPLS. If the earmarking order does not specifically mention tax-free lump sum, or PCLS, the pension investor can take the UFPLS which doesn't pay PCLS. There is nothing left in the pot to crystallise as it's known, and there is no income. These examples of the issues that have now arisen are simply intended to highlight the confusing nature of the position that now exists with earmarking orders. The reality is that in many cases, even unsatisfactory orders, ones that are not especially specific or well worded, may still work as intended, because the pension company has an obligation to fulfil the requirement of the order, and between them and any disadvantaged party, there may well be a variation of the order applied for to correct the position. However, there is no doubt that the earmarking option has become clouded as a result of the pension freedom legislation, which may have an effect on divorcing couples. And finally, pension sharing. Pension freedoms now open up the possibility that the non-pension owning spouse may prefer to have cash rather than a share of the spouse's pension fund, where the pension holder is aged 55 or over. This is made possible regardless of the age of the non-pension owning spouse, because it's the age of the pension holder that's relevant. Where the pension holder is 58 and their spouse is, say, 48, this is possible, even though the latter is under 55. As with earmarking, this becomes murky in its application in the real world, due to the nature of the tax position this could lead to for the pension holder, and also have a negative effect on their ability to make further contributions. So, although feasible, it does present challenges. The pension freedom rules tend to present practical challenges rather than outright technical challenges, and simply strengthen the case for the highest quality and specialist advice to be sought to cover the position in its entirety. I now want to talk about the lifetime allowance. This is the limit that an individual faces on the amount of pension benefit that can be drawn from pension schemes, whether lump sums or retirement income, and can be paid without triggering any extra tax charge. If it's exceeded, there are tax charges. The lifetime allowance was introduced in 2006 at a level of £1.5 million. It has been increased since, but then subsequently reduced to the current figure of £1,073,100. As with other areas of the pension rules, the way this allowance affects pensions and divorce considerations varies considerably depending on individual circumstances and the route pursued. For example, with offsetting, it really has no bearing. Where there is an earmarking order, the total benefits, pension and tax-free cash, including payments to be made through the order to the ex-spouse, are assessable against the pension owner's lifetime allowance and for their income tax liability, regardless of the fact that a portion of the benefits will be paid to the ex-spouse. The amount the ex-spouse receives under the earmarking order, including income payment, are tax-free. This can cause significant problems for the pension investor, where an earmarking order is sought and the lifetime allowance is relevant or could become relevant. In the case of pension sharing, the complications escalate where the lifetime allowance is a factor. It's worth noting that in many cases, the lifetime allowance is subject to protection, which means an individual can apply to have the value of the benefits they have built up protected from tax charges. Individuals who have previously applied for protection could have done so at a time when the allowance was a higher figure. The details of protection are not for this guide, but suffice to say, the way the lifetime allowance and protection works when a pension sharing arrangement is agreed is highly complex. There are instances where the value of the debit created by the pension sharing reduces the value of the pension for the pension holder, and this, consequently, reduces the amount of the sum for the purposes of the lifetime allowance. Likewise, the pension credit increases the value when considering the ex-spouse's lifetime allowance. Then the way any protection previously applied is affected also varies. In most cases, pension sharing is actually quite favourable in terms of the lifetime allowance calculation, as it effectively spreads the total pension value on divorce between two people rather than one, and each having their own lifetime allowance. However, as with all other factors, the position should be analysed first by a specialist. Another consideration is state pension. The basic state pension is not included in pension sharing schemes or earmarking orders. However, one partner may be able to claim a basic state pension through their ex-partner's national insurance. This would only apply to the years they were together as a couple and would not affect the ex-partner's state pension. This entitlement would be lost if they remarry before they reach official state pension age. There is, however, also the additional state pension, which can be shared in a financial settlement through the making of a pension sharing order. This means that part of the value of the additional state pension earned could be shared with a former husband, wife or civil partner. The court will need the details of any additional state pension entitlement. The additional state pension is an amount an individual may be entitled to in addition to their basic state pension. It's based on national insurance contributions and earnings since April 1978. A lump sum valuation will give this information and will help the court make a decision. If a pension sharing order is made, the additional state pension may either increase or decrease depending on the decision of the court. And now I want to quickly look at death benefits. Although a pension scheme is first and foremost a retirement savings arrangement, there will be value on death that the spouse would be entitled to during marriage. Therefore, on divorce, the death benefit will still apply should the pension member die before they draw their pension. How this is treated post-divorce and the effect this will have on each party is going to be a consideration. The loss of the insurance this provides could be very detrimental to the ex-spouse. Both parties will need to consider what impact the death benefits attached to the pension will have on their future positions and that of their children and other beneficiaries. This could be influential in deciding which of the three options of dealing with the pension is preferable. Another exceptionally important consideration is the difficulties of valuing a pension. A pension value is not necessarily set in stone. In simple terms, there are only two types of pension: defined contribution schemes and defined benefit schemes. A defined contribution scheme, such as a personal pension run by an insurance company or a SIPP, will have a value based on the underlying value of the assets of funds held. This value is reliable, although there may need to be some attention paid to whether any penalties for early encashment are included, and these may need to be factored in. However, more often than not, a defined contribution scheme is valued at the underlying value. So if the assets or fund are worth £100,000, then the pension value can reasonably be said to be £100,000. However, with defined benefit schemes, there are no such simple assumptions. A defined benefit scheme does not have a value, it has an entitlement. The most common example is the final salary scheme. Here, the individual has a future pension entitlement based on their salary at retirement date. For example, they may be entitled to 1/60th of their final salary for each year employed. For the purposes of a divorce settlement, this entitlement may need to be turned into a cash value, which is known as Cash Equivalent Transfer Value, or CETV. The CETV is a calculation which is open to variation depending on the underlying assumptions made. I will not go into the fine detail here, the complexities are too great for this summary and overview. However, it is possible for two experts looking at the same pension arrangement for someone in a defined benefit scheme to come up with two very different CETV figures. This is an essential point to grasp, because normally the CETV is provided by the administrators of the scheme and there is nothing to state that this cannot be checked, analysed and then, if required or appropriate, questioned and challenged. There are so many variables in calculating CETV, including whether discretionary pension benefits have been included, what discount rate has been applied, and what the expected earnings escalation is likely to be for the spouse who has the pension, amongst many others. Another consideration is the different issues before retirement as against after retirement. A reasonable proportion of divorces take place after retirement. There are different considerations to be made if a pension is already in payment. All three of the available options remain viable in some way, but the way that the offsetting, earmarking or sharing can be arranged will vary post-retirement than pre-retirement. Another consideration worth noting is court orders. Offsetting is a way of dealing with the pension that doesn't need the involvement of the court. Parties can agree their offset without a court order. The other two methods, however, require a court to make an order to support the intended outcome. In the case of pension sharing, this is because the pension provider or scheme cannot act to divide a pension agreement without a direction from the court. These court proceedings don't have to be contested, as in the majority of cases the parties have to come to an agreement through their solicitors, and only require a consent order from the court. The same applies with earmarking. The provider must make special provision to record the earmarking attachment, as this will not be implemented until the scheme member's retirement age, and this process is ratified by the court order. As I touched on earlier in this guide, Scottish law around divorce is quite distinctive, especially with regard to the overall process. This guide is concentrated on pension issues, not the wider ones. In this respect, I simply wish to bring forward that the considerations for the parties divorcing under Scottish law and how they view their pensions could be quite different. Just to highlight one example, Scottish law only considers the pension benefit built up during the time of the marriage or civil partnership. Where the pension value or Cetv is obtained, in Scotland it's then proportioned based on the length of time of the marriage. This is different to English law, where the whole Cetv is taken into account. I want to finish by talking about the importance of getting professional advice. Arguably, the issues and complexities involved with pensions in a divorce make this the most significant area of financial planning for individuals, where obtaining specialist qualified advice is a must. Having an appropriate, suitably qualified expert working alongside the legal advice is likely to be worth its weight in gold. Here are some of the main advantages a pensions expert will be able to offer in these situations. They will be able to help weigh up which of the three options is best to pursue. They can present the advantages and disadvantages of each option, based on personal circumstances and requirements. The advisor can assess the value of any pension, especially checking and evaluating a Cetv. They can advise an individual who sees their pension entitlement fall as a result of earmarking or a pension sharing order, including how to rebuild lost benefits. They can help an ex-spouse assess whether or not to keep a pension with the existing company or to transfer it when a pension sharing order is made. They can assess any loss of death benefits and how these should be replaced. They can weigh up the complexities arising from pension freedom legislation and also any that come from the lifetime allowance. They can help assess the post-divorce finances of an individual facing divorce. They can help with wider matters than simply the pension consideration, including post-divorce investment advice where an individual receives a lump sum payment. They can also look at the individual's financial planning goals generically and ensure that all family members, including children, are properly catered for. The information in this guide is based on our interpretation of current law and legislation and our understanding of HM revenue and customs practice. It's provided for general information purposes only and should not be relied on in place of other legal or professional advice. Both the law and HMRC practice will change from time to time, and our interpretation may be subject to challenge by HMRC or other regulatory bodies. Individuals should always seek appropriate legal or other professional advice. Thank you for listening. For more information, visit our website at interfacefinancialplanning.co.uk.